Good afternoon and welcome to the law. Meet the author of this book, Commercial Arbitration in Ghana, Bobby Banson. So what is commercial arbitration? What is arbitration? Why should I opt to stay out of court to resolve my differences, particularly when they are in the nature of business, contracts? Why should I not elect to go to court, but instead use another means to resolve my disputes? That's what we're going to be looking at. Commercial arbitration, staying out of court, with Bobby Banson, lead consultant, Robert Smith Law Group. This is the law. It's your legal light. It is your help law. I'm Samson Ladi Anyenini. We'll be right back. You're welcome back. This is the law. It's your legal light. It is your help law. And here we give you platinum legal education. I'm Samson Ladi Anyenini. And my guest is Bobby Banson, who is the author of this book, Commercial Arbitration in Ghana. We're going to seek to understand, as you have followed us over a period, we have tried to educate you on the law that allows you to take alternative steps to resolving whatever disputes you have rather than going to the courtroom. There are alternative steps, and we put all of them together and call them ADR, Alternative Dispute Resolution. Our courts are seeking to encourage a lot of that because those means or methods appear to be the ways by which disputes are resolved and people can still keep friendship, can still keep business relations. It is often a win-win and not a win-lose situation. Let's get to our Law 101. Here is the Law 101. And we are going to the Section 52 of the Alternative Dispute Resolution Act 2010. It says, an arbitration award is final and binding. Final and binding, as between the parties and any person claiming through or under them. Bobby Banson, what does this mean?
Good.
If I can get a decision which is final and binding, which is like what the court does, why should I be going to court, wasting my time and years and all of that?
Good afternoon.
Good afternoon.
It's a pleasure always to be with you, and good afternoon to your viewers.
Thanks for being able to join us under very, difficult situation.
It's okay. I think that we owe it a duty to our Ghanaians, let me put it that way, to as much as when we are called upon by you to come and do our public duties. So I'm always happy to be here. I think that the provision you just read, it's a very, very important provision that establishes the basis for the authority of arbitration. You'd recall that sometime this week, the Chief Justice, in her leading justice initiatives, spent a lot of time on discussing the court-connected ADRs.
That's right.
Which includes arbitration. She was very emphatic about the fact that justice per Article 125 of the 1992 Constitution is vested in the judiciary. Judicial power is in the judiciary. But justice emanates from the people. And so if justice emanates from the people per Article 125 have said the judiciary has ultimate judicial power. Arbitration is a means by which the people from whom justice emanates can hive off some of the judicial power and put it in the hands of private persons. So arbitration serves as a complement. It to the judicial processes. And so if Section 52 says that arbitral award is binding, it gives it the same force as the court's decision. Now, to put it in a historical context, traditionally, if people living in a community have a dispute, normally they will go to their family heads. If they are not able to resolve, ultimately to end up in the chief's palace. Mm-hmm. And whatever the chief's palace says is final and is binding. So normally you would realize, especially with land law, that most of the boundary disputes were settled by arbitration by the customary means. So the chiefs will sit and then say that, okay, we've looked at it, we've looked at this. This is where the boundary of Mr. A's land ends, Mr. B's land ends. And that decision by the chief, even though it was not formally written like we have with judgments and rulings, is not only binding on those people who were parties to the dispute, but their children and their grandchildren and their children's children. So that generations after, if one of the descendants come up to say that, oh, this land belongs to me, the other side can say, do you remember that in 1950, in 1960, there was a decision by the chief or this group of persons that decided the dispute this way or that way. Mm-hmm. And so it's not only binding on those that are parties to the dispute, but all the persons who will claim the same interest as those who were parties to the dispute. And that gives you that force, that judicial authority that Article 125 says is vested in the judiciary.
Right.
And so this provision sort of gives is the icing on the cake, for lack of a better word, for the authority that arbitrators or an arbitral proceeding has.
Is it correct to say we are seeking to use the state power of law to enhance what is indigenous to us?
You know, and this is a plus to Ghana. In a recent international arbitration conference, the use of the word indigenous, I presented this as customary. In fact, it is only the whole world. It is only in Ghana that our arbitration, Alternative Dispute Resolution Act, so I'll call the arbitration regime, has recognized the customary arbitration process. And so it is as if what our chiefs were doing, even though they may not have been formal in the sense of writing and pleadings and this and that, the wisdom in what they did. You recall that recently, or in our recent development, there's a huge chieftaincy dispute in some parts of the country.
Right.
That has been said, this one, it can only be settled by arbitration. And so there's a panel of eminent chiefs who are trying to have a resolution to that dispute. And so it is as if the policymakers recognized the wisdom in the historical approach to settling disputes between members of the family or cross-family members, as it were, or even a whole community against another community. And they have brought it into or formalized it in this sense. But the arbitration regime, as it were, the customary arbitration is only one part of it, where the informal, I'm using the informal in the sense of customary, is recognized. But when it comes to the commercial arbitration as well, whether domestic or foreign, then there are regimes or there are laid down rules and procedure that must be followed. But the force that it has, the state force, is the same. So that if there is an award by an arbitrator, even though the arbitrator is not a judge, that award can be enforced as if it was a judgment delivered by the court.
And you refer to customary arbitration and its recognition or legislation to formalize it, and that is in Part 3 of the ADR Act, we call it, Alternative Dispute Resolution Act 2010. And at Part 3, that is Section 89, it says submission to customary arbitration. A party to a dispute may submit the dispute to customary arbitration under this part, except otherwise ordered by a court and subject to any other enactment in force. A person shall not, A, submit a criminal matter for customary arbitration or serve as an arbitrator in a criminal matter. a person who contravenes this section, subsection, commits an offense, so and so. Right. So it does mean, because you just brought that customary part in to beautifully explain how we are formalizing what is indigenous to us to give it equal judicial power. It does mean that now, let's say it's sexy to do a customary arbitration and not be afraid that when I do it, somebody will say, this is not a court decision, so to hell with it.
Yes, it has the full force of law. There are a lot of cases. I remember I was reading a case recently involving a very important family or clan in the Greater Accra region, where the judges, Court of Appeal, relied on a customary arbitration that took place in the castle at that time. So there were rival claimants to the headship of the family. The head of state at that time was a member of that clan. He called the rival heads. They did a customary arbitration, wrote it down in the 1960s. Until date, any attempt to relitigate the matter is caused because of that customary arbitration. And so I think it's a feather in the cap of those who drafted the ADR Act to recognize it and then give people the opportunity to explore those avenues of settling dispute instead of always coming to court. We are all aware of the challenges with using the mainstream judicial process to settle dispute. Time being the most important challenge, where you have cases that have gone on for 43 years through the whole process. But one major advantage of arbitration is time.
We'll get there.
Okay.
We'll get there right away, because I've noted it and segmented in the way you have presented it in your book. And at section 111, that is 101, it speaks about enforcement of customary award. And it says, an award may be enforced in the same manner as a judgment of the court. Setting aside customary award, a party aggrieved by an award may apply to the nearest district, circuit, or high court to set aside the award on the grounds that the award was made in breach of the rules of natural justice, constitutes a miscarriage of justice, or is in contradiction with the known customs of the area concerned. Just a little comment on this section 112 before we proceed. So you could go and have the resolution of your dispute in the chief's palace through customary arbitration. And yet, a party may not be happy about the outcome. And the law says they can challenge that in the district court, circuit court, high court, if the decision was made in breach of the rules of natural justice, if it constitutes a miscarriage of justice, or the award is in contradiction with the known customs of the area concerned.
Yes, this is a very interesting provision. What must be noted is that you see the framers of the provision use the word challenge, not appeal against it. And it makes a lot of difference. Because if you say appeal, you'd have to go to the normal appeal process. But the challenge, and they have given you the grounds for the challenge, only 3. It means that if the award is delivered, customary award, it is binding unless you be able to prove only any of these 3 grounds. 1, the rules of natural justice, which may come in 2 forms. That the person who, or the panel that decided the dispute in that customary manner either had interest in the case or they did not hear you.
Okay.
They did not give you an opportunity to be heard.
So the rules of natural justice in 2-fold. A man shall not be condemned unheard. You must be giving a hearing before a decision adverse can be made against you. 2, you must not be a judge in your own cause.
Yes.
Right.
So those are the 2 forms. The other one is that the award
constitutes a miscarriage of justice.
Yes, I was going to go to the award is in breach of the known customs
of the area.
Because of, you see, it's customary arbitration. So you submit yourself to the chiefs or to persons that are vested with the customs of the area so that they decide the dispute in accordance with the custom. If plainly the award is against the custom, then of course you have a right to prove otherwise. And for example, we have lots of examples where in some customs, if you have a child with a married woman, that child belongs to the original husband, for lack of a better word.
That's my custom.
Okay. So if that is the custom and there is a dispute in relation
unless there has been a divorce.
Okay.
If there has not been a divorce, there's not been a proper separation, so to speak, and you have an affair with someone's wife, and that woman gives birth to a child, that child belongs to the original husband.
So if there's a dispute as to paternity, and it's submitted to customary arbitration, and the arbitrator says, no, it goes to the biological father, that is in breach of the custom of the area. And there's good reason for that custom.
Right.
That is why the law permits that some of these customs are allowed. Of course, essentially, we know it's to prevent persons from, taking on people's wives, as it were. And the last one, which is the miscarriage of justice, if you juxtapose the two, it's like the broader ground for any of these two. And so in interpreting and applying it, it is difficult to conceive another ground that will lead to miscarriage of justice outside these two grounds.
Perfect. Thank you so very much. You are here on The Law. It's your legal light. It is your health law. And we're helping you understand customary commercial arbitration in Ghana. And we are doing this discussion on the back of this book written by Bobby Banson, Commercial Arbitration in Ghana, Practice and Procedure. So correct me. I know that Justice Dennis Ajay of the Court of Appeal, and who is also now on international courts panels, must have been the first to write about our ADR Act, a book.
Yes.
And then Justice Brobe, retired, also wrote about the ADR Act. Then, in my estimation, this is the third, but this takes a different kind of taste because it is concerned with customary arbitration.
Commercial arbitration.
Commercial arbitration.
Yes.
So am I correct?
Yes.
Okay.
Actually, the first book was, I think it was co-authored by Justice Ajay and Barbara Akaye.
Yes, Barbara Akaye is correct.
Yes, who's now the Supreme
I'm familiar with the two books, yeah. So
yes, I actually had
I moderated the launch of all those books.
Okay.
Yeah.
Okay, with Justice Ajay, and he has provided a lot of guidance with this book. So thank you, sir, once again. Now you notice that this book emphasizes on practice and procedure. And as you were, every laws normally have two sets. You have the substantive law, which determines the course of action, then the rules of practice and procedure, which determines the how and the when, and the manner, the form, the content, and the time to ventilate. So the two books you have mentioned essentially deals with the substantive aspect of the ADR Act. Now, what I did was that in Ghana, there are two major ADR arbitration centers. We have the Ghana Arbitration Center, and then we have the Ghana ADR Hub. Now, what I did was that I looked at the rules of practice and procedure. So, for example, how do you start arbitration at the Ghana Arbitration Center? How do you start arbitration at the Ghana ADR Arbitration Hub? Do we have some sections in the Substantive Act, which is the Act 798, which overrides certain provisions in the rules of the ADR Center or the ADR?
I highlighted portions of that, but let's begin this way,
okay,
so that our audience can follow the education. Commercial arbitration, what is it about?
Now, because we had discussed customary arbitration, I would want to touch that, and then, so arbitration in the Ghanaian context will take four main forms. We have the commercial arbitration. It could be domestic or international. So there could be international commercial arbitration. There could be domestic commercial arbitration. Now, Commercial arbitration deals with dispute that arises from commerce, trade, usages, all those kind of transactions between individuals, so not the state. So if Samson Limited, Bobby Limited, or Samson as a natural person, Bobby as a natural person, enter into a transaction and one person is not happy with it, it constitutes a commercial dispute. If we have an arbitration agreement, then it could be a dispute arising or a commercial arbitration. A dispute arising from commercial transactions would be a commercial arbitration. If one of the parties is cross-border, sort of Bobby is in Ghana, Samson is based in the UK, then it becomes an international commercial arbitration. But if both parties are in the same jurisdiction, then it becomes the domestic commercial arbitration.
Right.
Then there is the investment arbitration, which involves the state. So there's the investor, a foreigner, who comes to Ghana to invest, then there's a dispute. So if you look at GIPC, Ghana Investment Promotion Center Act, it states that any dispute arising out of an investment by a foreigner would be settled first by means of arbitration. Right. So that becomes an investment arbitration, which has the element of a state as the host state of an investment.
Right.
Then we have the customary arbitration,
right,
which we have discussed.
Yes. Right. So I'm here, or I have my company. My company has a contract with another company. We are all in Ghana. And trouble comes, disagreement comes. I thought that the first thing most people would do is that we run to the court. So how can I resort to an arbitration instead of going to the court? How does that work?
The parties must first agree to use arbitration as the means of settling the dispute.
You stress that over here, and I underlined it.
Yes, lots of marks.
Yeah.
So
they must first
agree. The agreement must be unequivocal. It must be unambiguous.
Right.
So there must be an arbitration agreement before the dispute can be resolved by arbitration. Now, this is the good thing with arbitration. The arbitration agreement can be executed either before the dispute or after the dispute. So even if in your original agreement, you do not put in an arbitration clause, when the dispute arises, you can agree subsequently to settle it by arbitration. So that is the good thing.
So we have a contract. The contract doesn't say that if a problem arises, we will settle it using arbitration. We can now agree on, there's a problem that has come up. One is contemplating going to court or doing something. Then we say, yes, we can still agree that this is how we want to settle the matter. We don't want to go to court with it.
Yes.
That's what you're saying?
Yes. So the arbitration agreement could be before the dispute arose or after the dispute has arisen.
Right.
But there must be an arbitration agreement, which must state unequivocally that the parties intend to settle the dispute by means of arbitration. Now, because arbitration involves hiving off some of the judicial power from the courts into private persons or private institutions, the arbitration agreement must also mention who the parties intend to act as the arbitrators or which institution the parties intend to administer the arbitration. So putting there that you want the dispute to be settled by arbitration is the good start. You must go further to state who you want to resolve the dispute or who you want the arbitrator to be, or the institution that you want to appoint the arbitrators, or the authority. We call it the appointing authority. So sometimes the parties, for example, can put in there that when a dispute arises, we will settle by arbitration. The arbitrator shall be the president of the Ghana Bar Association, or the Ghana Bar Association president shall appoint the arbitrator, or the dispute shall be referred to be settled by arbitration but at the Ghana Arbitration Center.
Or the Ghana
ADR Hub.
ADR Hub.
Or in accordance with the rules of the ADR Hub. So the parties must not only state that they desire that their dispute be settled by arbitration, they must also state who they intend the arbitrators to be, or the institution that will appoint the arbitrator. In fact, they can even choose the applicable law.
Right.
So they can choose that even
law
though
it should be used to settle the
arbitration. So for foreigners who are doing business in Ghana, that is a very good tool that they use. So for example, in our country, we have a lot of Lebanese businessmen. They both will enter into agreement, but because their personal law, as we call it, is Lebanese law, even though they are doing the transaction in Ghana, they can decide that when there's a dispute, we want the Lebanese law to be applicable to the dispute, even though we are in Ghana.
Right.
And we are choosing or we are doing the business in Ghana. Or beyond that, we want the president of the Bar Association of Lebanon to select who the arbitrator would be. That is the freedom that arbitration gives you.
The freedom, so you're already discussing the advantages. The freedom it gives you includes the opportunity to choose who will resolve your
dispute. Yes.
The opportunity to include what law we will use to resolve our issue.
Yes.
So,
and even where.
And even where.
Even where. You can decide to say the venue, or what we call the seat of the arbitration.
Okay.
You can decide to say, even though the transaction is based in Ghana, we want the dispute should be resolved in Singapore, or we want the dispute should be resolved in Hong Kong or London. You have the freedom. That is the beauty of arbitration. Right.
So, if you have said first, which one is the best way? That when we are doing the contract, we put it in the contract, or separate and then do an arbitration agreement when the problem arises. Which is the best way to do?
I always advise that it's better to put it in the substantive contract. So there are two ways. Some parties would have the contract that will govern the transaction. Then they will have a side contract like an annexure that would govern the arbitration or the dispute resolution. Or they could include the dispute resolution as a separate clause in the main contract.
Which is what is frequent.
That is what is frequent. Now, it's better to agree on the dispute resolution mechanism before the dispute arises.
Right.
Because most of the time, once the dispute arises, it's difficult for the parties to even agree. Now, that is where sometimes the courts can be of assistance. Because if you look at our High Court civil procedure rules, the amendments that have been done, at the application for direction stage, or at the stage where the court will determine the issues and the way the case will proceed to trial, the court can suggest to the parties that looking at the issues involved, even though you do not have an arbitration agreement, I am advising or suggesting that you try and do court-connected arbitration.
That is even if it were not in the commercial court.
Yes.
Even if it's a case that has gone to the commercial court, then it is mandatory that there will be a first attempt, pre-trial mediation.
Yes, at mediation.
Right.
And then if even with the new proposals by the Chief Justice, it seems to suggest that arbitration is even being associated with the pre-trial settlement, the practice directions that have been proposed.
Right. So in that practice direction that has come by the CJ, you can, instead of the judges being the ones who would normally help you to resolve it at the initial stage, that's the pre-trial mediation stage, there is the opportunity to have third-party, mediators and arbitrators to come in. So they say mediator or arbitrator to come in to resolve your matter for you. Are you suggesting that if I found a contract now, maybe myself and my landlord, we entered into an agreement, a tenancy, and then we put in there that if any problem arises, we shall resolve the problem by arbitration, and we just left it there, that would not work?
It would work. It would work in the sense that it is an indication of the party's truest intention to resolve the dispute by arbitration. Now, in practice, normally, because it merely mentions arbitration, without mentioning who the appointing authorities would be or who the arbitrators would be, the practice has been that where that arises, one party may write to the other that we have the dispute, we have an arbitration clause, but we did not agree on further mechanisms.
As in who will be the arbitrator or who is going to appoint the arbitrator. Good.
Can we do that now? If there's no consensus at that stage, one party may In fact, we still have that provision in our CI 47, which was based on the old Arbitration Act of 1960, which has been repealed by the Act 798. One party may file the action in court, like the normal proceedings, because the arbitration agreement can be waived. So even though you have signed the arbitration agreement, you can waive it if an action is commenced in court and you do not raise the arbitration.
All right.
So when an action is commenced in court and the party raises that, hey, you can't go to court at first instance because we have an arbitration agreement, then the other party can say, yes, I agree we have an arbitration agreement, but we do not agree on further mechanisms. So can the court now make orders as to the further mechanisms? And that is where the court will play that role of saying, okay, I see there's an arbitration agreement, but there's the absence of the appointing authority. I'm referring the parties to go and see the registrar. For the registrar to give you, and the registrars at the high courts in Accra, they have a list of arbitrators.
All right.
They will share it with the parties and they'll give you timelines within which to select or agree on the panel of arbitrator, whether it will be a sole arbitrator or a panel of 3.
Right.
If you do not agree, the registrar under those circumstances will be constituted as the appointing authority and appoint an arbitrator for you.
Right. What is the best way to go about it? To name who you want to be the arbitrator or to appoint an institutional head to decide who will be the arbitrator or arbitrators, or to use one of the organizations, as in the Ghana Arbitration Center or the Ghana ADR Hub?
I always suggest that parties should have institutional arbitration instead of the ad hoc arbitration. The ad hoc arbitration is the one administered by named persons. Sometimes at the time of executing the contract, the person may be alive. At the time the dispute arises, the person may not be alive. Or at the time the dispute will arise, the person may be conflicted in that manner. Then he leaves another room to drag the whole commencement of the proceedings. But if it's an institution that is named, then you do not have these issues arising.
Is it not the case that the ad hoc arbitration is cheaper?
That was what I was going to say.
Institutional.
The real reason for the ad hoc arbitration is I've done ad hoc arbitrations before, and it's normally cheaper and to some extent faster because you immediately sit there and you agree on the rules. And so it can be done within a very short time. The arbitrator selects a convenient place. They sit within 1 day, 2 days, they are done, you go. But the risk with it comes, or some parties may even decide on the ad hoc arbitration post the dispute arising. That may be a better approach. So they do not put the names there in the agreement, but after the dispute has arisen, they can now agree that looking at the nature of the dispute, we think that this person has the expertise. Let's go to this person. And
that brings me to that point. What do people consider in deciding who should be their arbitrators when they are determining it?
Internationally, there are certain guidelines. We normally refer to what we call the IBA, the International Bar Association guidelines. There is the competence, which is the most important thing, which connotes the skill and the knowledge in that subject area. Then there is the question of whether you are conflicted. So the conflict is, okay, despite the competence, despite the knowledge, you are interested in that matter because you've either acted as counsel or you've been consulted, or you have a relationship with any of the parties, or you are biased towards the subject matter. So that if the person has the competence but is conflicted in either of these, either you are biased or you have so the word used is independence. So the conflict comes in two folds: the independence of the arbitrator and whether you are biased towards the subject matter. So independence means you have a relationship with any of the parties, prior or during, that will prevent you from exercising independent judgment. The same with the bias, that adds to that subject area. We know that as for you, when it comes to awarding interest, because you're a Muslim, you do not believe in interest. We've done arbitrations like that where the arbitrators, we said, no, he is a Muslim. they don't believe in awarding interest on loan transactions. So if you make him an arbitrator, he would only award you the principal. So he is biased on the subject matter.
At page 93, you speak about factors, you write about factors to consider in appointing an arbitrator or arbitral tribunal. And then at 94, you come to speak about, you say, apart from having the requisite skill set and expertise, it is generally expected that arbitrators must be persons, A, of high moral character, in the context of not being corrupt or susceptible to being influenced to change the outcome of the award. B, persons with recognized competence in the fields of law, commerce, industry, or finance, in the context of being able to appreciate the issues to be resolved and understanding and applying the relevant laws to resolve those issues. C, persons who are independent of the parties and the unbiased, impartial towards the dispute or a party to the dispute, so that where the arbitrator has had any relationship with the parties or any prejudices about the substance of the dispute which will influence his decision-making, the arbitrator is expected to disclose this fact for the parties to decide whether to keep him or not. And finally, the person must be one who can be relied upon to exercise independent judgment, devoid of the groupthink syndrome. Going back to B, where you talk about the person must have some competence in fields such as law, commerce, industry, finance, or the context of the issue. So if we were entering into a contract about, say, telecoms, and we wanted to put an arbitration clause there, we must choose arbitrators who are familiar with that area. Is that what you're saying?
Normally, that is so you'd find out that in recent times, a lot of our professional institutions are establishing ADR centers. So the Ghana Institute or the Ghana Institution of Engineers, they are recently setting up an ADR center because they've noticed that some of the disputes relate to their subject area, and they do not, even though they are members have the competence of engineering, they may not be trained in the arbitration space. So they are setting up a center so that they can have their members trained in the practice and procedure, so that when there's a dispute construction-wise, we know that, okay, let's appoint or let's state that the appointing authority shall be the Ghana Institution of Engineering.
Right.
Now we have the Ghana Institution of Surveyors. Recently, I'm privy to discussions by the Lands Commission itself that is trying to set up a center so that family disputes and things like that, because you are aware that when there's boundary dispute, you go to court. The court says, let's appoint the regional surveyor to come and give us a report as to who the boundary owner is.
Right.
And so the Lands Commission, I'm aware of discussions where they are setting up a center to resolve some of these private matters, some of these disputes between families and stools and private individuals in respect of land. So we can be looking at that direction when we are looking for persons with the requisite competence and skill in that field, so that we do not put, they say, round
square pegs in round holes.
Exactly.
Okay.
Exactly.
So a quick summary by way of just a list. What do you say are the advantages of the resort to arbitration rather than going to a court to litigate?
In your introduction, you made reference to the most important advantage, the win-win situation. In court, there's always a winner, there's always a loser. In arbitration, that hardly happens. As much as possible, the panel will ensure that people's interests, instead of positions, are advanced. That is one. So that you maintain the business relationship between the parties and there's a resolution as to the issues.
Right.
Two, deals with the speed. So that once it is arbitration, you're able to determine the timelines within which you resolve the dispute.
Right.
So that you can decide to say, this one, within 3 weeks, we should be done and done with. And every party is bound by it.
You treat the advantages in page 34 going, and you speak about the right to select an expert to adjudicate the disputes.
The freedom.
Freedom to choose who must settle my disputes. Then you also speak about what you just mentioned, the speed. But you add to the speed finality of the proceedings.
Yes, like you read section 52, that because it is stated and agreed that an award is binding,
Final and binding.
Binding, as if it's a decision of the court. But the advantage is that
even though you chose private persons, you sat in your office, you entered the contract, and you decided that if there is a problem, I want Bobby Banson and something to resolve the matter for me. If there's a problem, I want the head of this organization to choose somebody to settle the matter for me. It is not a court that has settled the matter. You chose who should settle
the matter.
And yet the outcome
is binding.
It's as good as a court judgment.
It's as good as a court judgment. In fact, for lack of a better word, I dare say better than a court judgment. The reason being that with a court judgment, if it's a high court, or assuming it's a district court, you have a right of appeal to the Supreme Court. But when it comes to arbitration, there's no right of appeal against the award. But you can challenge the award on very, very limited grounds under Section 58 and 52, I believe, whether it's domestic or international.
The question also comes up, if it is a court that gave me the judgment, and you don't obey the judgment, the court will use sanctions against you. They will use the state powers to collect the money for me, garnish your bank account, all sorts of things. If it is this one, and it is Kweku Mensah sitting somewhere who settled the matter for me, what will happen?
It is the same, something. If arbitrators, even though they are acting as private persons, deliver an award, the Act 798, which is the Alternative Dispute Resolution Act, provides for the means by which the award would be recognized and enforced by the court. So the party who is, we call the award creditor, the person who got some orders made in his favor, will file an application to the court that we did an arbitration based on this arbitration agreement. The institution or the person was a competent arbitrator. The arbitration was in line with the terms, the procedure that we've agreed, and in line with the rules of court. So the court should adopt it as part of the court, as if it was a judgment delivered by the court.
One of the advantages you talk about also is the confidentiality and privacy of the dispute resolution process.
I was going to land with that.
I'm sure many people will love that aspect.
It is one thing that really encourages arbitration. Because with court, your matter is out there. Any person can walk to the courtroom to listen to your case. But with arbitration, you decide who sits in the course of the proceedings. And so even the award is not published except with the consent of the parties. So if I start arbitration with something, nobody else will know that I have an arbitration with something. But if I have a court case with something, anybody can go to the registry and do a search. Is there a case involving Samson Ladi? Can I get copies of all the processes that is filed? RTI bail will entitle the person to get it. But with arbitration, no. You cannot,
private. It's confidential.
You cannot publish anything relating to the arbitration, even the final award, unless with the consent of all the parties. So that confidentiality is very, I know a lot of multinational companies, let me say, without mentioning names, those that engage in exclusive distributorship agreements, they always insist on arbitration. Because if they have a distributorship agreement with you and they terminate it, especially in the telecom sector, they terminate it, and then tomorrow they give it to somebody else and you commence arbitration, that person will not know the nature of the award that was delivered. So that they cannot use it as judicial precedent. To come and say, when you did this, you awarded this, so and a lot of businessmen are in favor of that confidentiality provision.
You are still here on The Law. This is your legal light. It is your health law. And on The Law, we give you platinum legal education. And this afternoon, we are privileged to host Bobby Banson, who is lead consultant at Smith. And he he writes this book, Commercial Arbitration in Ghana, Practice and Procedure, and we are seeking to help you to appreciate better what is contained in here so that you can resort to arbitration without necessarily getting into unnecessary court processes. Bobby Banson is lead consultant, Robert Smith Law Group. I want us to end on the note, who is paying this arbitrator that I have the right to choose?
You are paying. So if it is an institutional arbitration, the institution would have their own sets of costs. So you are aware
of their fees.
Of their fees. If it is an ad hoc, you select the person, you are allowed to negotiate. But you are paying for the expertise. You're also paying for the confidentiality. And you're also paying for the speed. And so if you consider the cost, it's like the value that is bringing to you outweighs the financial implications.
And the expertise, some say, is very essential, even not about the privacy matters, but the expertise because you could take your matter to court and the judge sitting on the matter doesn't know about this area of your
Commerce.
Industry.
Yes.
But you can pick somebody you know has the best or is the best in that area, and they will help you resolve it very well. Now, on this note, let's end here. Is it not expensive, more expensive than going to court, when you guys continue to say this is a cheaper way?
Well, the cheaper way is in terms of the value that is bringing to you. Like they say, you don't want to be somebody who knows the cost of everything, but the value of nothing.
None.
For real businessmen, the cost of the arbitration far outweighs. And let me give you this scenario. If it is a highly scaled dispute and you go to court, you would have to hire an expert. Even though the expert opinion is even not binding on the judge. You would have spent money hiring that expert. Then why don't you agree with the other side to choose that expert to deliver a binding opinion?
Right.
And so in the long term, it gives you more value than the money. And there are some, the Ghana Arbitration Center, the Ghana ADR Hub, they have what they call expedited proceedings.
Right.
So depending on the value of the dispute, they can decide to do it less, like they have different schedules of cost depending on the value of the dispute. So there's not flat fee for everything. So if you approach them, you take the cost schedule, you know that in the long term, you get more value for it.
Right. And as you have followed the Chief Justice lay out her vision, Chief Justice Georgina Wu did a lot in promoting ADR, court-connected arbitration. She was the one who lifted that to a very high pedestal. And all Chief Justices have sought to also promote it. And Chief Justice Araba Esaba Saki Tokonu also has now released some guidelines to help in this direction. Thank you so very much, Bobby Banson. He is the author of Commercial Arbitration in Ghana, Practice and Procedure. You've heard me speak to him sometime earlier on civil litigation in the High Court of Ghana. He's the author of this book as well. His lead consultant, Robert Smith Law Group. Thank you so much. This has been The Law. It is your legal light. It is your health law.